Very good evening, one and all. On a lighter note, legal era has got 40 under 40. That itself is a lot of privacy and data issues. Everyone knows who's under 40. Yeah. Well, we've got a very power-packed session or a powerful speaker session. Thanks to all my fellow panelists. Thanks to Akriti, who's made my life easier with the brief introduction of each of the panelists. We promise you that every panel immediately before lunch or immediately before spirits are a problematic session. We'll keep it as brief as possible, but we can have Q&A sessions if at all you are interested in some questions in a short while. With the introduction of the panelists already behind us, DPDPA Act has been long due. We know what is data, we know what is personal data, we know what is digital personal data. Not all personal data is under the statute, but only a digitized form of it. We will get to that in a short bit. But all of us know that after years we had the Puttuswamy judgment of the 9 judges in 2017, which was followed by the Sri Krishna committee report, which had 10 members. So we had 9 judges and 10 committee members. Probably 19 of the stalwarts have put 2 things behind this. And if you actually see the Sri Krishna committee report, the recommendations which were given in about 6 or 7 chapters possibly are the same chapters in the DPDPA Act. Funnily, whether it is how the data is to be processed, who's a data fiduciary, what are the obligations, and also what happens when data is sent out of India. With that broadly, I would possibly think of telling all of you, those of you who have studied it, it's still a statute, the rules are still to come out. We've got many players under the statute. One is the principal, who's the first person whose personal data we are talking about. When a person is born, we get a birth certificate. We take that and get an admission into school, and then we have secondary school leaving certificate. We take that to college, and then we go into employment. All of these are data which are collected over a period of time, and then medical records, so on and so forth. But broadly, under the statute, we have the data principal whose data we are talking about. And then there is data fiduciary, as in the person who's collecting the data. And then there is data processor who is possibly processing the data. It can be the fiduciary or it can be a third party. And then we have consent manager. We'll talk about that in a bit. The specialized speakers will talk about it. That's something very unique to India, unlike a GDPR. And of course, we have the regulatory body as well. Without much ado, I would turn to Vasanthika, Deepa, Srinjoy, and Nagaraja and ask each of you, all of you, each of you have been in-house, all of you, each of you have handled data in mid-size, large-size, mega-size numbers as well. So can you go around and tell me briefly what your roles have been, what kind of data, what kind of industry you represented, how are they processed in the current regime, before the new law comes into force?
Thanks, Bharath. So I have, in my role at Concentrix, I implemented GDPR. So what we basically did was I was the DPO and responsible. We are largely processors. It's a customer experience company which provides services. So most of the personal data that's processed is processed on behalf of various data controllers, in India data fiduciaries. So the employee data that we process, we are the controllers and the fiduciaries. And then of course there are vendors and your marketing and some of these for which we are considered as the controllers or the fiduciaries. So largely, my larger part was obviously as a processor, but given over 3 lakh employees globally and 80,000 in India, we have a huge number for which we were the controllers, and we have so many various methods of information security. We want to keep people working with camera and all of those. So we had a lot of these sensitive issues around how you manage employment, and we dealt with all of those as part of both GDPR and various other regimes and DPDP. That's my background on privacy. Deepa's is most interesting in this.
Deepa, for all your background, has got 1 billion data. So she'll talk about why it is 1 billion.
So thanks, Bharath. So thanks to Legal Era and all my co-panelists and other interesting session panelists and the participants. Actually, it's a very hot topic which Bharath opened up. And I had the legal function as well as a DPO role for Quess and its group companies. Almost 38 plus companies spread across 10 plus countries. So you can imagine the amount of data what we handle. We are the largest business services provider in this India, at least in the APAC region. As Bharath indicated, so we do have, I'm sitting across on more than 1 billion, approximately 1 billion data resumes, okay? It may be active or inactive, and it's complete or incomplete, whatever form, okay? If you put it out as a resume, how much this is the overall database we work on. And we do have 500,000 employees deployed across 3,000 plus clients in India only. You name your industry and sector, the top 10, they are customer to us. So it's, though I may be in the staffing industry, but predominantly I do have the knowledge about or what is the expectation of your BFSI or healthcare or insurance or e-commerce business. So as a data processor, we do know the other side of it, what kind of compliances which is expected. As a data controller, I myself has been collecting a significant amount of data in my system. So a lot of controls and a lot of obligation and liabilities which arises. One. The other one is another company of my own company. I think why 1 billion, maybe I'll take it. It's Quess itself is in the company, and where we have acquired a company like founded us where it's called as a monster, and Q jobs, these are all the applications where the job portal. So today we do cater for a blue collar, grey collar and all the IT professional job services. The other one is our own, another company is Alsec. We do process every month, it's at 1 million base, both for our own employees as well as for our clients. So you can imagine that it's not just a personal data, it is a very significant, why we are calling, they are all calling the Quess as the mega database or whatever they are. So this is one. What challenge where I face in terms of as an organization like us, first of all, we are a very diversified sector. We do have a 35 plus companies and different nature of the services, more than 50 plus business which are payroll or manpower or facility management, security services or technology, ITS. And if you look at it, the definitions of the personal data or categorization of a data itself is different for all these companies. When you try to put a framework or a governance metric, I cannot just go with the one size fits for even within my own organization or a same business I do a staffing in India, I cannot replicate in Singapore or probably in Philippines. I need to look forward for each and every law, customize it, and it's a bit difficult. And it cannot be easily given in one line to any of my internal stakeholders. The take time will come. The same application when I am implementing in India, you have written a different. When I am going to Singapore, you are giving a different rules. Deepa, are you going mad or you are making me mad? And it's making them to understand. It's a bit difficult. And the rights and remedies of the data principle, it varies. Today, India, we don't even have a category of other than personal data. It's only one classification. When you go to GDPR or you go to Singapore or CCP, it's altogether different. And again, the liabilities and obligations of a controller, when I'm looking at an enforcement mechanism, that's a key crucial part for us. And these are all some of the challenges. We look forward for the later part of the discussion, how it takes for. Thanks.
Thanks, Srinjoy. So you've been in-house, out-house, and back into in-house and
yes,
out-house. So
I have traveled the journey. Last 10 years I have been in this space. So right now I am the partner of LexOrbis, developing their data protection privacy practice. But my journey started in 2013 when I was a DPO for JetPact and as well as an IP attorney at that point in time. But the laws have evolved. The law has evolved from the GDPR time. So we had a period of 2 years to comply. But believe me, and this is for everybody over here, 2 years is also very, very short time for compliance. This is because when you are an organization like a JetPact, who was earlier a back office of GE, you are talking about countless data sets, as Deva was saying, that there are countless data sets. So we are processors most of the times. You are the controller or the data fiduciary controller in the GDPR, controller for the data that is lying with you, employee data primarily. Then I did that 5 years. I built up the data protection, the GDPR aspects of it. 2017, as you rightly said, 2017 is when Putuswamy came in. I went outhouse. I went on my own. Worked with organizations, trained lots of people on this topic of data privacy, and then I joined Bioformis, which is a healthcare AI space. Again, healthcare and
Closer.
Oh, sorry. Healthcare and AI space. So again, we are talking about a lot of data that you are talking about, very sensitive data. This is, in terms of GDPR, you are talking about the special category of data that is the sensitive data. So the challenge over there was, how do we anonymize this data so that it takes it out of the whole spectrum of GDPR? Now with DPDPA, we are seeing a lot of traction of clients trying to understand what the DPDPA is, trying to understand how do we comply with it. Primarily, the first point of contact is the privacy policy, but and we will go into more dynamics on it.
Thanks, Sujay. That's seeing it on both sides of the coin. And Naga, you've been on the advisory side and on a couple of advisory services, and can you briefly tell us what you've been through?
Sure. Thank you. Firstly, thanks to Legalera for the opportunity. And one disclaimer, all the views expressed by me doesn't constitute a legal opinion. It's just my personal view, nothing to do with my company. So currently I'm in the consulting house. Basically, I work on typically what Deepa mentioned and Vasanthika mentioned. It's basically in-house problems are basically happy problem for consultants like me. So we are trying to solve those problems. So typically I run privacy programs for my clients, specifically like manufacturing industry, banking, and many other industry, where we start with a gap assessment kind of thing, try to understand where their data is, or what is the discovery, who owns the data in terms of where they collect, where they store, and then probably getting into the awareness mode, trying to make them understand what kind of compliance will be, what kind of laws will be applicable, because nowadays we talk about globalization, we talk about cross-border data, and then typically we also look at the impact assessments whenever there's a cross-border transfer, and also in terms of new product launch, they have to do a DPIA, that is Data Privacy Impact Assessment. So I've been on the journey for about last 5 to 6 years in the data privacy. Prior to that, I was mostly on the IP regime. So now you can guess what would be my next journey. It would be mostly on the AI as well, because all the IP lawyers will go through privacy first and then probably the AI journey as well. So I think I'll hold it a few more things for the next discussion.
Yeah. Thank you. I mean, with the amendment and the privacy becoming a fundamental right, more and more corporations are having specialized key personal, one of those key personal individuals like DPO, Data Protection Officer, data, CIO, CTO, Chief Information Officer, Chief Technology Officer, Chief Information Security Officer, and you have many functions which come in overlap. So quick question to both Vasanthika and Deepa is, what have been the changing roles of these DPOs, DISOs, DSCO? I mean, there are so many jargons around which you would know better than outhouse counsels like us, external counsels. But what do you think, for two minutes, that the new law would expect these specialized officers to act or equip themselves differently?
Thanks. So I'll go back to the GDPR journey because that's where the separate privacy office creation began. So what happened in the past was data privacy was part of information security. The companies will be required to say, do you have a data privacy office? The CISO will say yes and will act as the privacy officer, and it was a check in the box activity which happened pretty much until 2017, 2018 for most companies. But GDPR clearly said that the DPO cannot have a conflicting role. So you cannot be a HR person, you cannot be legal, you cannot be CISO, obviously, or IT. So a person, I was handling compliances, and compliances was seen, privacy law compliance was seen as an extension of regulatory compliance, which is why I just happened to be in the place, I upskilled and I became the DPO. So I just assumed that role. And until then, it was data private, it was a part of the CISO's role. And that's how it was in most companies. Gradually, it has evolved from DPO. Now you will see a separate data privacy officer, and then you will see a separate chief privacy officer who is overseeing all the DPOs. So we've seen that evolving. The most important thing is the DPDP does not talk of a conflict of interest or what a DPO's qualification, role, etc. is. It only says that it's a person who should be in India and reporting to somebody senior enough. So, therefore, we have to see what the rules will say, whether they will also talk of conflict of interest. But most of the companies which already have a separate privacy organization will continue running it the way it was. Companies that are purely in India and are going to be creating something will obviously create something based on the requirements of the DPDP, and in such cases, if there is no express conflict of interest requirement, I won't be surprised if the CISO office will take over that, and or there will be a fight between the legal and the CISO's office over who wants to claim that. So that is how things will pan. Now I'm moving into your outhouse role, so I will be with you watching how that shapes up in the industry, and Deepa will be there to take that forward.
Thanks, Vasanthika. I think partially I agree with you, partially disagree on it. There's some different perspectives from my end. So overall, when we look at it, right, any data protection law, irrespective of any country, I think 71% of the countries has a data protection law. Recently, India has been joined in that, from a 15% of that position of having only the privacy law as a draft form. I think that's a great leap. And as Vasanthika said, India right now, only the significant data fiduciary needs to have a DPO. Still the rules are yet to be notified, but we are looking forward that DPO needs to directly report it or coordinate with Data Protection Board as well. So somewhere the interpretation comes, the data DPO and the organization also needs to report to the board directly. But slightly we are taking an interpretation at this point in time. But the DPO role is very crucial. I keep telling the organization, any enterprises hires any resources, it can be CISO or a GC or whatever level, they always look forward for the interest of the organization. But the role of a DPO is slightly different. But the object of the Data Privacy Act itself is different. There are two perspectives on it. One, the Data Privacy Act should protect the interest of the data principal. The second, it has to enable the business of the enterprises. That's the object of the act. When it comes to DPO, he'll be appointed by the enterprises who's supposed to protect the interest of the data principal who is outside the organizations. The second one is he has to equally enable the business of the enterprises. So it's a very, very delicate role and he has to maintain the balance between these two things. So as Vasanthika said, there is a conflict arises. Who can perform? Including legal function. How the conflict arises has been evaluated is what is the quantum of data which every organization or every business line, including us as a support functions or enabling function, we do collect the personal data. I think when we take that as a list, predominantly the legal team has the lowest one. So when they put the weightage on it, the conflict of interest, why can't the GC become a DPO when compared to a CISO or a CTO, or you call it out as an now the new role which has been emerging is a Chief Data Governance Officer or Chief Data Officer, CDO. Because that is both personal data and non-personal data. Maybe data can be a business. So that's the another one angle to it, an IP. So my look at and my feel is that probably this would be aligned more towards a legal team on a couple of reasons. One, the nature of a conflict of data managed by the legal team is comparatively lower to the other roles. That's one. Second, who can be potentially drafting your policies, process, and your agreements, especially which is a key to prevent or proactively work on your risk or any litigation. And it's easy if anything grievances arises to pass it on to one team, irrespective of whoever is the owner. Even a DPO can be the person. But I think the grievances or litigation arises, it ultimately lands up to the legal team. I think considering those parameters, I think it's shaping up. And it's a great opportunity for many of the GCs, I can say that it's a hard role. And other one data point I want to leave it to all of you. In the last 3 months, it's been 35% of the job postings are primarily with respect to the requirement of data privacy officer or probably the part of the team. So it's good to note and probably that's a good journey there. Yeah.
Just one point I would like to make to supplement what you said. See, the role of the CISO, the role of the CIO, rather the role of the CISO, I would say. There is a conflict. There's a direct maker-checker problem that is there. And legal is always an advisor to the company. So the way that globally it's arising, there is an ethics organization, there is a legal organization, there is the information security and IT organization. So and then the fourth one is the risk. So these are the 4 places where the DPO can possibly sit, but let's see how
when laws are amended to bring in a compulsory legal officer, it's good news for the legal industry. It's like every company had to have a company secretary, and then the rates of company secretary went up. Sorry, Naga, you had to say something.
Deepa mentioned legal plus DPO. Legal can be a business enabler, but not a DPO. Technically, because DPO is a supporting role. Even though, no, not necessarily, because DPO, if you look at the overall function wise, it's a supporting, you are only an advisor. So you cannot be a business enabler, especially when you're having a dual hat. So as a legal person, you can be an advisor and you can be an enabler to your company. Not a DPO, you don't have to worry, you cannot be an enabler. Because at the end of the day, what doesn't work, it doesn't work as a DPO.
No,
You should red flag.
If you have to support the company, you have to enable it, and you have to creatively find ways to enable the business and find them alternate solutions, and that's what corporates look for.
No,
but that's a matter of
debate.
debate.
Because at the end of the day, then the conflict starts.
Interest of time, I think we'll have.
Yeah, but I just also wanted to point out that what we have to also see is whether the external DPO kind of a role will also become soon.
Yeah.
So that is another
Yeah.
interesting.
So for
to
all
watch.
of
So
us,
people like me.
all of us to an extent.
I like that. External, and she's on the door, opening the door. That it's also important that whether it's a small, medium or large corporation, there is a lot of requirement in compliance. I mean, what does one company have to do before the rules come and then the law becomes up and running? One thing is to go back home and see what data you have, what kind of data you have, live, dead, etc., and then see it through and then see whether you have consent. So that takes me to the next set of questions to both Srinjoy and Naga, is that what is that you see in the consent management and compliance, and how do you kind of balance it with the legal principles and the legal requirements?
Right. In fact, this is one of the mainstays of any compliance that is there. GDPR talked about one set of rules. They are talking about the lawful grounds. There are 6 grounds that are there: consent, contract, legal obligations, vital interest, public interest, and legitimate interest. Now, in India, when the original draft by Justice Sri Krishna was put up, it was still better. What it did was, and even the 22 version, what it did was it put it into 2 categories. It put it into, there is a consent and there is a deemed consent, and in deemed consent there were various things, and there were various exceptions that were there. There was one point on lawful purpose, which was similar to legitimate interest in GDPR. Now what the Act has come out with is that there is consent and then there are some legitimate uses. Now, one thing for the audience also is that legitimate interest in GDPR talked about a balancing of rights between the company's rights and the user's rights, individual's rights. But legitimate use over here does not talk about that. Legitimate use talks about a situation where when there is no consent, you have those parameters like medical treatment or medical emergency, employee data that is there. There are various other grounds also. So there is a difference that is there between the GDPR and this is the nuance. Why I talked about this is the nuance that the companies need to understand. There has to be a consent mechanism. So as you rightly put it, you have to start from the very basic. What is the basic seed in the organization is the personal data. Or if we look at non-personal data also, we are talking about data as the seed. Now, where is that in GenPat, for example, when I was building it up, just to try and get where all the personal data is was a task. So your data mapping, your understanding of where the gap lies, what is the gap that is in your organization, a gap assessment has to be the first stages of compliance. The interesting part is that the government is talking about a period. There are 2 things that the government is saying. The government is saying that one, whenever the rules come in, the companies that have already been adhered to GDPR have a very short period of time. And even for the others, it's going to be, say, a period of maybe 1 year maximum. But the challenge that lies is that unless organizations start their journey early, start building up, understanding where their data lies, understanding the gaps, doing the assessments, doing the risk assessment, taking that call, and going forward on that journey right now, they will miss the bus by the time the Act is. And there are challenges. There are lots of challenges that are there.
Especially when they are threatening that the winter session might have the rules forward.
And you are talking about, absolutely, and you are talking about penalties that are going up in the terms of 100 to 200 crores for the organizations. And this is for one offense, it can be 100 crores. It can be multiple offenses as well. And even as data principals, that is the individual, we have a 10,000 rupees fine for not meeting which is a typical thing for the Indian Act, which is the duties of the data principal. So, I'll allow Naga to take it forward, but this is the thing.
Thanks, Srinath. So basically, whenever we talk about consent, typically we get 3 questions. I'll try to cover it like a Q&A so it becomes easy. I don't want to get into too many details. See, what are the basic grounds for personal data processing? There are only 2 things. One, you need a consent from the data principal. And the other one is, as Srinath mentioned, there are some certain legitimate interests. Say, suppose you want to purchase on Amazon, Flipkart, you say, I agree to terms and conditions, all those things. So basically, you're agreeing, right? And then, now, how do we comply? Say, do we need to issue a fresh privacy notice? Right? Now we have already given consent. We don't know when we gave. Sometimes for a quicker login, we use Google. We don't use separate sign-on. Lot of things we have already done. So now we look at all the companies now, especially once the rules are notified and they start sending you fresh consent requests, right? So what are the things as a company, for example, say maybe you are in house, somebody is asking you what you can do properly. So one, you can start sending a fresh notice once the rules are formed, and you can probably take a fresh consent and you can start maintaining the fresh consent and the records for your future purpose, right? And what should the privacy notice include? Maybe because of GDPR and other things, everybody, all the websites would already have typically your B2B or B2C website, or even your general website might already have a privacy notice. But you can go back and probably check whether you have personal data collected, what kind of personal data is collected, what is the specific purpose you are collecting, how to exercise the right for withdrawal of consent, then in case of grievance redressal method, and how to complain to the board. So these are the typical 4 to 5 things you need to include. And one last aspect, whenever we talk about consent, what exactly would be a consent would be typically? It should be specific, informed, unconditional and unambiguous with clear affirmative action and limited for specific purpose. Say suppose, there are so many challenges as I mentioned. There can be typical challenges. Say suppose you are working at some organization, right? So, and say after this you will tell, since anyways it's month end, many of you salary might not have got credited. You go back and tell, don't process my data. Maybe tomorrow or day after tomorrow you might not get your salary. Please don't do that as a data principal, right? And then typically, if you are a B2C or a e-commerce kind of a organization, you might have to have all the official languages under the 8th schedule of the Constitution. You need to include that also. So a lot of compliance would be required. And on top of this, the government is proposing similar to CIBIL kind of a thing where a consent manager would be there who would manage all the requests, means wherever you are given permission, allowing your consent to which company, and all those things you can manage. Maybe you can withdraw the consent, or you can ask for erasure of data. All those things that can be possibly done, but definitely it will take some time. Don't expect the moment the rules are formed, you will get it. Maybe over a period of couple of years, we can see something on that aspect.
Thanks, Naga. Much of debates or comparison obviously happens with GDPR. So my next question to both Vasanthika and Deepa is quick 1 minute on what is the 15,000 feet difference between GDPR and DPDP, and also under the DPDP, what would happen to all the agreements you would have entered into with the principals, with the vendors, with the data fiduciary, with the processors. There are like 6 or 7 metrics. And then what Naga just mentioned, that under the schedule you've got 22 languages. You need translators to come in. So can you quickly speak about 2 minutes on each of you on this?
So, at a very high level, one consent is pretty similar in both GDPR and DPDP, except that GDPR talks of people that privacy by default. It's a concept which has been mentioned in that you cannot have made a default, you cannot have people opting in. It is the default position and people need to opt out of the privacy if they want. So that is the one thing in difference in the concept of consent, but otherwise they're pretty similar. The other differences are basically about on the lawful basis for processing versus the legitimate uses, the way it has been worded in the Act, which makes DPDP heavily dependent on consent. While in GDPR we could do a data privacy impact assessment and say that I have a legitimate interest and a reason to process this, and I don't have to go back and take consent. So now the requirement for consent goes up in DPDP. So the same thing that would have been performed may not be able to be performed in the same way in an Indian context. Then there are some more differences like the DPDP does not have exceptions like journalism and archiving and things like that, which have been expressly called out in the GDPR. Then, of course, we don't have concept of sensitive personal data, which is a very important thing, hopefully, which we will see in the rules. And then there are also things like the right to nominate, which is very unique. We don't have the right for data portability. And then a very unique thing is our consent manager, which will get discussed again. And then one thing that I feel is really lacking again is the lack of clear clauses on privacy by design, encryption, and we have been left to just to have reasonable security technical measures. So what is reasonable security measures hopefully will come out in the rules. Otherwise, it's left each organization is left to their own devices. So there are some of these differences that are.
Just one clarification I would like to give is that technology and law are two sides of the coin. So technology will always run very fast. Law will always play catch up. That is a fact, and that is why in both the GDPR and in terms of the DPDPA, they have left the language loose. Even if you see the reasonable standards that are there currently, IT rules, they have left it very loose because the technology that is needed for protecting the information of, say, your information, because the Quess Corp's information might be very different from what is the information that is for an FMCG company or a very, very small player. So the technological and organizational measure that needs to be adopted will be very, very varied and different, and therefore they don't define that point. One more thing that in terms of consent, when you were talking about, one more thing about consent is that consent in GDPR, they have a whole mechanism that is kind of elaborated. You have a timeline for the consent. There is a consent withdrawal. There is a consent life cycle. Perhaps the 25 sets of rules that are going to come out might one of them or should contain this. Of course, there are some typical things like right to nominate that is there.